Okay, I was talking to somebody about a case they got going in court, and they've been asking for a quick and speedy trial, and it's being ignored. So if you remember, I told you about a quick and speedy trial is guaranteed to you in the Sixth Amendment, but I told you that it's not going to happen unless you ask for it. Well, even in the law clearly states, if you don't ask for it, you're not going to get it. But if that's your right, why do you have to ask for it? Which I find totally ridiculous. But here's another thing: if you don't demand, you won't get it. It's called a probable cause hearing. Okay, so the kid he's talking about is not only just getting denied quick and speedy trial, but he doesn't know this. Nobody brought it up. He's being denied a probable cause hearing. It was a family dispute, an argument. The police arrived. They escalated it by arresting someone because, of course, when they go out on a call, they have to come back with an arrest. But nobody's pressing charges, but they got him in court, and they're trying to convince him just to take a plea bargain. But there's nobody actually pressing charges. Nobody's coming to court to press charges. It was a family dispute. But nobody's going to bring up this. Okay. A probable cause hearing is a court proceeding that determines if there is enough evidence to prosecute a defendant. The purpose of the hearing is to ensure that the defendant is not tried without justification. Here are some details about the probable cause hearing. To determine if there is enough evidence to prosecute the defendant. Evidence. The prosecutor presents evidence the defendant committed the crime. The evidence is usually brief and focuses on the most important facts. Cross-examination. A defense attorney can cross-examine the witnesses to show weakness in the state's case. Burden of proof. The burden of proof is lower than a trial requiring only a fair probability that the defendant committed the crime. Most preliminary hearings result in finding a probable cause, but the court may find no probable cause if the evidence is very weak. A probable cause hearing can also be held for someone accused of violating the terms of their parole or probation. Okay, so, as far as effective assistance of counsel, you're guaranteed that in the Sixth Amendment as well, but the requirements are in the rules of professional conduct and the Code of Judicial Conduct. And if you don't bring that up in court, nobody's going to play by the rules and nobody's going to play by the codes. So thus, you're denied ineffective assistance of counsel, so you don't have a fair trial and you're not getting due process. Okay, I'm just trying to make it short and simple for you. Look up the rules of professional conduct, the Code of Judicial Conduct, and when you do, don't forget to also look up the rules of professional conduct complaint form, the Code of Judicial Complaint form, and start there. Okay, it's self-explanatory. Listen, I learned this a long time ago, and if I can learn it, so can you. My academic credentials don't exceed that of a GED, but I couldn't afford an education, but I was able to afford time to read what I thought I needed to know, and that was a law. Any law, every law. When I was a kid, I wanted to be a lawyer, but, the costs. But I always had time to read, and I had to dig and fight for this information here, and that was long before the internet, or before I even had access, and the only thing I had to rely on was the Dewey Decimal System. So take advantage of what I had to fight for, okay? Everything I'm showing you are the laws that are on the net, and due process doesn't exist. And you can prove it to yourself if you just go over all these things I'm telling you about, okay? I posted more than one video. You should really watch them all. If you find this one interesting, you'll find them all interesting, because that's a lot of stuff that's not happening. Okay, see why I'm so pissed off? What happened to me is happening to we. I've been through this stuff before, and I've helped through other people through this stuff before. And the only reason we got anything done was by taking the law with us to court and demanding a probable cause hearing, quick and speedy trial, a jury trial. Why would you trust a judge to judge you or your case if he or she is not abiding by the rules of professional conduct, the Code of Judicial Conduct? Any violations of either or is mandatory to report in both the rules and the codes. And so it's the judges and the lawyers' legal obligations. It's the judges and lawyers' legal obligations, not just to report any violations, but to enforce these rules in a court of law. But they don't. They don't enforce them. They don't abide by them. Okay, that's effective assistance of counsel. It's described in the Rules of Professional Conduct and the Code of Judicial Conduct. Okay, a lot of people got mad at me. Hey, if they know this is their job, how come they're not doing it? They're asking the wrong person. I'm just giving them the law. And I tried to explain to them, you got to say that in court. This is your job. How come you aren't doing it? You took an oath to do this. When you took an oath to the Constitution, U.S. Constitution, to serve and protect, you took an oath to serve and protect we the people who the Constitution was dedicated to. And you took an oath to make sure that I have due process, I have a fair trial, that I have effective assistance of counsel, and then you're going to go over what effective assistance of counsel is. And none of that's happening. All right, you remember Martin Luther King's speech, I have a dream that our country will one day live up to its creed, that all men are created equal. Okay, I'm just elaborating on that dream.